Okay, well, first of all, let me thank Haim for accepting my proposal and especially for organizing this conference, because I'm really excited to be here. It looks like a wonderful program. So I'm presenting here a small part of my research, and I've been having a project, research project. I've been working on a project regarding the clash between Italian civil law and Jewish law after the unification of the country, the unification of Italy in 1861. And my project goes up until the end of the First World War. And I've been working on this for quite a long time, but then in the last 3 to 4 years, sort of life got in the way, and I didn't really manage to complete the research. So this is still a work in progress, and I really hope I will be able to complete the research and write a book soon, this time, for real. Now, I came to Jewish history from Italian history, and vice versa, so to Italian history from Jewish history. So the two perspectives are strictly interconnected for me, and I really tried to create a dialogue between these two fields of research, because in Italy what usually happens is that you have Jewish historians doing their bit and Italian historians doing their bit, and the two don't really communicate. So I was trying to be that link, to embody that link a bit. And I came to this project on divorce and intermarriage coming from a research on the integration of the Jewish minority in Italian culture, politics, society. And then I didn't really at the beginning have the intention to focus on marriage, intermarriage and divorce, but then with the progress of my first research, it became evident that this is a crucial issue. If you want to study really the integration of the minority in Italian society, and this is not only true for Italy, of course, marriage and everything related to marriage and intermarriage and divorce is crucial from every perspective. So the perspective of social history, cultural history, religious history, it is really, really crucial. Now, let me just very, very quickly list some characteristics of Italian Jewry and Italian Jewish history. I'll be very, very quick. So we are talking of a very tiny minority, around 35,000 Jews in Italy in the 19th century, and around 35,000 Jews in Italy nowadays. So it's a very, very, very tiny minority. We are talking of a minority which was, at least in the 19th century and the beginning of the 20th century, very, very fragmented. And this comes, of course, from Italian history. It's a characteristic of Italian history. Italy as a unified country only exists starting from 1861. And then we are talking of a minority that didn't, Italian Jewry didn't didn't know Reform Judaism up until very, very recently. And we always have to keep this in mind when discussing the integration of the minority and in Italian society and culture, and when we are dealing with these issues of marriage, divorce, intermarriage. So the first Reformed synagogue was inaugurated in Italy, in Milan, in 2001. So it's a very, very different situation if you compare it to Germany or France or the UK or the United States, of course. And then Italy was, and still is, a very Catholic country. Again, when dealing with marriage, intermarriage, divorce, debates on these issues within Italian Judaism, we need to always bear in mind that there is this general context of a very, very Catholic country. A very Catholic country that in the second half of the 19th century and the beginning of the 20th century was fighting against the Catholic Church. So you have a very Catholic country in open conflict with the Catholic Church. Because of course, in order to be unified, the Italian state had to fight against the Pope, who was occupying basically the center, the geographical center of the peninsula. So there was the relationship between the Italian state and the Catholic Church was very, very difficult. And this sort of helped the integration of the Jews in many ways. Now let me begin with a quotation. This is a quotation taken from one of the most well-known Italian Jewish periodicals of the time, which was called the Vessillo Israelitico. We could roughly translate it as the Jewish Standard. And this piece was written by a rabbi, Flaminio Servi, actually the director and the founder of this journal. This is taken from an issue of published in 1875. And Flaminio Servi, this rabbi, is trying to understand, to reflect on how we can conciliate Italianness and Jewishness, and Jewish religious law and Italian civil law. And he says, citizens and Israelites, we must study together to reconcile, to the degree that we can, the responsibilities that fall to us in one or the other role. It is not appropriate to cite at the wrong moment, as many, however, do, the rabbinical saying, Dina de Malkuta Dina, because this only applies in relation to civil laws as long as it does not damage the most sacred religious principles. If, however, using the law as a pretext, people wish to impose customs and orders that contradict the spirit of Judaism, then we must, with all our strength of mind, make our rights understood and respected, those rights which that same freedom of worship allows us. So, this was tricky, of course, because respect for the law of the state and relinquishment of any kind of special jurisdiction were the direct, desired, and unavoidable consequences of emancipation. The modern concept of equality provided for an end to discrimination, but also for an end to privileges that at some points and in some places had characterized the life of the Jewish minority. The regulations on marriage, and more generally the issue and custody of documents regarding civil status, differed widely across the pre-unification states. For example, before the unification, the legal codes of Piedmont, the Estensi Code, Parma and Piacenza, Modena, and the Two Sicilies, these codes did not provide for civil marriage, while in other areas of the peninsula you had civil marriage. Now, what does it happen with unified Italy? The first unified civil code was came into force on the 1st of January 1866. And what does this code say regarding marriage and divorce? It introduces civil marriage in the Italian legislation, but this civil marriage is an indissoluble civil marriage. So the Article 148 approved the principle of the indissolubility of civil marriage. And there was the possibility of legal separation in some specific cases, but of course that's not divorce, that's something different. Marriage was removed from the control of the churches, and the celebration of the religious ceremony became completely irrelevant from a judicial point of view. There were many concerns for Jews after the approval of this civil code. On the one hand, the introduction of civil marriage meant that intermarriage became possible, an actual possibility. And on the other hand, the civil code outlawed divorce, which was, of course, a possibility for Jews from the perspective of the halakha. So there were the approval of the code stimulated a heated debate around intermarriage and divorce. And the whole debate happened in the context of a broader debate that was about the integration of the minority into Italian society, culture, and politics, and how you can really conciliate Jewishness and Italianness. How and if, and of course, all these people thought you could actually conciliate, but at some price, so you had to pay a price. So Jewishness and Judaism have to adapt in some ways in order for this integration to really become a reality. I'm going now to present to you some of the extracts from this debate, especially regarding divorce. So what was the reason given by the Minister of Justice regarding this indissolubility of civil marriage? Giuseppe Pisanelli, this was his name, stated many times that the reasons for this decision were not religious and did not imply any reference to the model of the Catholic marriage sacrament, but instead derived from moral consideration of a secular nature. Divorce, it was argued, would have represented an element of corruption of morality and social customs and would have undermined the survival of society's fundamental unit, the family, endangering the education of children, female honor, and public order. So on such a delicate issue, the prevailing sensibility profoundly impinged upon reservations that had originally been dictated by religion. So what do the Jews say about this? So various positions were adopted. There is no unanimity on this topic. And the debate has mainly two phases, one in the 1860s and the other one in the 1880s, because in 1881 a bill to introduce divorce was presented by the then Minister for Justice, but it was repealed, so there was no divorce only becomes a reality in Italy in 1970. So this is a long story. It goes on for a century. So one meeting in Ferrara in May 1863, the civil code was under discussion. It was not in force yet. The representatives of the Italian Jewish communities resolved to send a request to the government for approval of exceptional status for the Jewish minority in order to ensure that the religious law on divorce would apply. In justification of this request, they expressed their belief that the indissolubility of the matrimonial bond derived its rationale from the religious faith of the majority of Italians. And of course, they were right, but as I said, the minister, and not only him, they strongly denied this. And it is true that Catholic culture is so deeply rooted in Italian culture history that it is very, very difficult sometimes to separate what comes from Catholic culture and religion and what is separated from it. It's really impossible actually to separate these two things. But in 1864, Marco Mortara, the rabbi of Mantua, and actually the father of a well-known lawyer, Lodovico Mortara, who will then become Minister for Justice in the late 1890s. So Marco Mortara was an important figure. And he wrote in 1864, so there was this debate, and the civil code was still under discussion in Parliament, the draft for the civil code. So Marco Mortara took a strong position on this issue with a pamphlet entitled Civil Marriage Considered in Accordance with the Norms of the Law and of Appropriateness. And he has a long historical introduction. He illustrates the complexity of the positions of Christian churches in their attitude to divorce. And he actually supports the Minister for Justice position, and he tries to dispute the Catholic origins of the principle of indissolubility of the marital bond, and he supports the validity of the political and social reasons put forward by the minister for the insertion of indissolubility in the new code. And he states religion is the only effective bond among family ties. The mixed marriage is, for the minister of religion, a cohabitation which civil law, in the interest of society, is obliged to legitimize. So he's taken a strong position on civil marriage, in favor of civil marriage, even though it allows intermarriage. And then he says state law is their supreme law, in the presence of which every claim must fall silent, since the state asks its citizens for nothing that is in discord with the rational principles of the laws of Moses, which are in perfect harmony with natural religion. And actually his position, Marco Mortara's position in support of the idea of indissolubility of civil marriage has a huge success. And it is based on the idea that really, in order to foster the integration of the minority into the new state, Jews had to put religious law in second place and actually only aim towards the integration into Italian society and culture, accepting even this different idea of marriage, which is very much rooted in Italian culture. It is still very much rooted in Italian culture. Of course, you have even different positions of, for example, a lawyer, Isacco Rignano, actually defying this idea of the indissolubility of civil marriage and stating that it goes against religious freedom. So this is another, but he doesn't get much support actually, because the main interest is in really showing the compatibility between Judaism and Jewishness and Italianness, between Judaism and the values rooted in Italian society. And let me conclude just to the last the last text I would like to quote a little extract from. Is a very famous pamphlet written by Vittorio Polacco. Vittorio Polacco was a Jewish Italian lawyer. He was professor of civil law at the University of Padua, and he intervened in this debate in 1894, so in the second phase of the debate, and after actually divorce had been reintroduced into French legislation in 1884, after being absent from the French legislation for a while. And Vittorio Polacco actually strongly supports the idea that civil marriage should be indissoluble, and that even religious divorce should become less and less frequent. Of course, religious divorce was still possible, but didn't have any civil effects. But he states very clearly that, in his opinion, Jews should avoid even religious divorce in order to get more integrated into the general culture. And very interestingly, he was Jewish, but he tries to explain why divorce, in his opinion, is not it's just an extreme possibility, even in Jewish law. So it's not something that Jewish law really supports, Jewish religious law. And he tries to explain this point by quoting from the Gospels. So he doesn't quote from actually Jewish halachic sources. He quotes from the Gospels. He quotes in Latin from Matthew, the Gospel of Matthew, when Matthew really speaks of Jewish law. And this is an interesting thing he does, and it actually really shows how he is very well integrated into this general Italian society and culture, and he becomes a senator after a while, and he's very famous actually because he then made an important speech in 1925 during the fascist regime against the reform of education supported by the regime. So one last quote from Vittorio Polacco's pamphlet. He says, there is not and there cannot now be one moral rule for the Jewish family and a different one for the Catholic family, while what civil law has to regulate is the Italian family, which is of just one type in its ideals, sentiments and customs, whatever kind of religion is practiced within it. So as a way of just a last conclusion, just something to conclude, I would like to remind you that actually for the Italian case, we don't have reliable data on intermarriage, or we do only for specific local cases in a very short period of time, and we don't have any research on actually the practice of religious divorce and therefore of get refusal and agunot as well. I found some documents in the Jewish community of Livorno for the first half of the 19th century, and these documents stated very clearly that rabbis were trying to discourage divorce as a practice because it would not be seen well by the majority society. And I'm looking forward to getting your questions afterwards. Thank you.